In this video, we're going to continue on with a discussion of pretenders to power and more about the effects of Roman civil law and law merchant on this country. The Federal Bill of Rights was drawn and adopted to guarantee an estoppel or bar to the abhorrent federal executive and legislative equity jurisdiction, and therefore the State Bill of Rights is also a guaranteed estoppel against any actual or de facto abhorrent state executive and legislative equity jurisdiction. This is an abhorrent and oppressive equity because it purports to be able to administer, adjust, and deny said common law rights without first pursuing the appropriate remedy at common law and thus denying due process. In other words, state government, both executive branch and legislative branch, must be at law and may not impose any form of equity jurisdiction upon the people by compulsion or otherwise without their knowledge and informed consent, that such enactments are nullities and do not exist at law, because the rights of free-born sovereign individuals would be violated if they were being forced to obey them. If an agency of the government, including the court, would act as if it were principal and freeman, as against its true principal, the people, this would be an inversion of the legal principle of sovereignty of the people. And by so acting, this agency of the government, including the court, would be a pretender to the power. And as a pretender, its acts would be a nullity and would not exist at law. That is to say, that it would be null and void, and of no force and effect at law. That in fact, it would not be government at all, but would be a private criminal operation, imposing a rule of force, fraudulently pretending to be a government, since in this country, the only legitimate function of government is to protect the rights and freedoms of the people. Each free-born sovereign individual has the authority and the right to deny and to disavow all equity jurisdictions and to refuse to acquiesce to the jurisdiction of the courts of equity or to equity jurisdiction of any executive or legislative branch of government, agency or agent, state or federal. The Constitution for the United States of America, Article 4, Section 4, guarantees a republican form of government to every state. The definition of a republic is as follows: a state in which the sovereign power resides in a certain body of the people, the electorate, and is exercised by representatives elected by and responsible to them. That's from Webster's. Now, as an example, the courts of Iowa are nullities and don't exist either at law or in equity because unelected state judges have no jurisdiction at law or in equity over anyone or anything, being in direct violation of each freeborn sovereign individual's right to a republican form of government, his right to have an elected judge, and his right to separation of powers, because the governor, as the chief executive of the state, has no judicial power to delegate to an appointee. The governor is not a chancellor, nor are any officials appointed under him authorized to exercise any judicial powers. There can be no delegated power in chancery law to be executed under the alien, outlawed, and illegal Roman civil law unless acquiesced to by the freeborn sovereign individual. The de facto equity jurisdiction of the Roman civil law allows judges to enforce the unlawful summonses of IRS agents, highway patrol officers, city policemen, building inspectors, OSHA agents, FDA agents, and the agents of all other equally unlawful regulatory bodies of so-called government, who attempt to impose a jurisdiction in which the rights of freeborn sovereign individuals are violated. Roman civil law allows judges to have people arrested, jailed, and property taken away from them, or their property to be criminally trespassed upon and destroyed, all without a common law trial by jury, or just compensation or due process of law. Under the common law, no bureaucrat can dictate what happens to your liberty or your property. The only entity that can determine punishment and pass sentence upon a freeborn sovereign individual is a lawfully constituted common law jury. Aiding and abetting the IRS and similar agencies in enforcing their unlawful summonses and assessments constitute an enforcement of the alien Roman civil law. Aiding and abetting the highway patrol officer, the city policeman, the meter maid, the building inspector in enforcing traffic tickets and other unlawful summonses constitute an enforcement of the alien Roman civil law. Compelling a freeborn sovereign individual to do anything except upon the verdict of a common law jury constitutes an enforcement of the alien Roman civil law. Thomas Jefferson's been credited with the warning how the judicial branch of government would usurp the authority of the executive and legislative branches of government and turn the country into a judicial dictatorship. On June 5, 1933, as a result of a prearranged banking crisis, the Congress of the United States passed House Joint Resolution number 192, suspending the gold standard. They did not abolish it, which means they disestablished the fixed content of the gold dollar and took away the law jurisdiction of the U.S. standard dollar lawful money. In effect, the entire country, every state and every freeborn sovereign individual became insolvent and was effectively put into bankruptcy, making it impossible for each state and each individual to either pay their debts at law or to be paid at law. This was, in actuality, a criminal act of usurpation of the sovereignty of the people by Congress. Instead of being able to demand payment at law, or to make payment in standard gold dollars or the equivalent treasury currency redeemable on demand at par, everyone was forced onto the credit of the private banks, the Federal Reserve banks, and the commercial banks, and began to pass around their debt instruments as money, making use of their debt claims for the money, and thereby the operation of House Joint Resolution number 192 into an alien and unlawful federal executive equity jurisdiction known as the law merchant, previously discussed. Law merchant is the private rule of bankers, and from which jurisdiction our forefathers fought and won a revolution to be free, and from which jurisdiction our Constitution and Bill of Rights protects us. When you can pay your debts in standard gold dollars, you operate on a cash basis in a federal common law jurisdiction based on Article 1, Section 10, Clause 1 of the Constitution for the United States of America regarding tender in payment of debts. This is the general federal common law jurisdiction deriving from the Union, which, the Bill of Rights was designed to protect, particularly the Seventh Amendment, which guarantees the right of trial by common law jury in suits at common law where the value is in controversy and shall exceed $20. But when you pass around evidence of debt as if it were the money itself, you are passing around the debt claims for the money, and you no longer have a jurisdiction at law where the individual has access to his rights, but you are in an entirely different court or jurisdiction. You are in an equity jurisdiction, one in which the individual does not have any rights. And this is the practical effect which Congress intended to bring about by passing House Joint Resolution number 192. Even 100 years ago, it was stated that we have the best Congress that money can buy.